Hello and welcome to Lunchtime Politics, reaching you live from our global headquarters here in the nation's commercial nerve center, Lagos. Let's bring you the big stories that we're tracking in the polity and in politics, beginning with the headlines. Supreme Court dismisses the appeal by the Rivers State Governor Similar Fubara, challenging the leadership of the Rivers State House of Assembly led by Martin Amiewule. Apex Court also give judgment in other cases today. The Deputy Speaker of the House of Representatives, Mr. Benjamin Kalu, says the Green Chamber only received proposal for state creation and not the House proposing issues of state creation as circulated in the media. And the Socioeconomic Rights and Accountability Project, SERAP, sues President Bola Tinubu and Minister of Finance over alleged failure to identify and prosecute erring government contractors. Thanks again for joining us in the program. There's a lot going on in the court, especially at the Supreme Court in the nation's capital, Abuja. It's going to form the crux of our conversation. There are potpourri of issues, especially when it comes to Rivers State, from sister appeals to all sort of cross appeals. We'll get to that in a moment. But let's tell you that drama was happening in court today as Justice Binta Nyako of the Federal High Court Abuja adjourned indefinitely the alleged terrorism case against the leader of the indigenous people of Biafra, Nnamdi Kanu. Mr. Kanu, who was visibly angry, said there is an order for Justice Binta Nyako to recuse herself from the case, accusing her of being biased over his case. Mr. Kanu's trial was stalled after Justice Nyako recused herself from the case following an oral application by the defendant on September the 24th, 2024. The IPOB leader directly told Justice Nyako that he no longer had confidence in her handling of his trial. However, the Chief Judge of the Federal High Court, John Soho, reverted the file to Justice Nyako on the ground that Mr. Kanu's application must be brought formally before the court through a motion on notice. At the resumed hearing today, Justice Nyako says the Chief Judge has not accepted the recusal and has referred the case back to her. She asked the defense team, led by Aloy Ejimako, to write a written application if they still insist on the recusal. Earlier, the prosecution counsel, led by Adeboyega Awomolo, said they were ready for the commencement of trial as his witnesses were ready.
The prosecution and this court doesn't know the law. That is the fact.
Yes.
Poor knowledge of the law is killing Nigeria. Poor knowledge of the law, they don't know the law. This is a federal gazetted law of Nigeria that says here that the Chief Judge of Nigeria cannot tell Binta Nyako what to do. It's here. It's your law. Just obey it. That is why I do what I do. I agitate for Biafra. I agitate for Biafra, my right to agitate. My right. They turned it from treasonable felony now to terrorism. Stop talking when I'm talking.
And away from that incident at the court earlier today, let's tell you that the Deputy Speaker, I should say, of the House of Representatives, Mr. Benjamin Kalu, has been providing clarity as to what is the state of issues around state creation. It is said there was an announcement that applications have been received and not that the House of Representatives is producing or proposing this issue of state creation in the Constitution Amendment. Let's take a listen to him.
What we did was to announce to the public, the members, through their members, that we have received, not that we have proposed, but that we have received proposals from the ethnic groups through memoranda and also through proposals laid in form of private member bills in the House. Having said that, most of those propositions, those applications, they were not in tandem with the provisions of Section 8. So, as we are at the moment, there is no effective application for this state creation before the Parliament. But to cure the gaps existing in their application, we have been magnanimous to extend the time that we had given to them when we called for memoranda by giving extra 30 days for those who want the state creation to be carried out to comply with the procedures laid down by Section 8 of our Constitution. And this will be ending on the 5th of March of this year. So what it means is that before you lay your application before us, there are, preconditions that you must fulfill. The referendum must be signed by 2/3 of the state houses of assembly, local government, members of the parliaments who are in support, both in the Senate and the House of Rep. Then you present it.
Let's tell you that the Socioeconomic Rights and Accountability Project, SERAP, has initiated legal action against President Bola Tinubu, accusing him of failing to instruct the Minister of Finance and Coordinating Minister of the Economy, Mr. Olawale Edu, to identify and prosecute contractors who received over 169 billion naira from 31 ministries, departments, and agencies without executing any of the project. This allegation is based on the findings from the 2021 audited report by the Auditor General of the Federation. Joining the lawsuit as respondent is the Attorney General of the Federation and Minister of Justice, Mr. Lateef Fagbemi, who SERAP urges to take appropriate legal action against implicated companies and contractors. SERAP suit filed on Friday, February 7th at the Federal High Court in Lagos seeks to compel President Bola Tinubu to direct the Finance Minister to disclose detailed information regarding the projects in question. This includes the project locations, the amounts paid to each contractor, and the company names of their shareholders, as well as the name of the company. SERAP argues that the alleged corruption involving these contractors has significantly hindered access to public goods and services for impoverished Nigerians. I said there's a lot coming in as far as the Supreme Court is concerned, and that is why we're working our phones to be sure that we capture every bit of what is going on as far as that is concerned. So let's tell you what exactly is happening at the Supreme Court today. Earlier, a 5-man panel of the Supreme Court led by Justice Uwani Abaji has dismissed the appeal filed by the governor of Rivers State, Siminalayi Fubara, challenging the leadership of the Rivers State House of Assembly led by Martin Amewule. Justice Uwani Abaji, while addressing or dismissing the appeal, awarded a cost of 4 million naira against the governor payable to the Rivers State House of Assembly as the first respondent and Mr. Amewule as the second respondent. Meanwhile, the dismissal of the appeal by Governor Fubara is hinged on the withdrawal of the suit by his counsel, Mr. Yusuf Ali. The court is set to hear 2 appeals filed by the All Progressives Congress challenging the legality of the local government elections conducted in Rivers State last year. The court is hearing the suit following the conclusion of preliminary proceedings by Justice Uwani Abaji, who led the 5-member panel that ordered parties to file and exchange their respective briefs before the 10th of February, that's February the 10th. The appeals are against a judgment by the Court of Appeal in Abuja, which reversed an earlier decision by Justice Peter Lifo of the Federal High Court, restraining the Independent National Electoral Commission from releasing the register or voter register to the Rivers State Independent Electoral Commission, RISEC, for the purpose of conducting LG elections. Justice Lifo had predicated his decision on the grounds that the condition precedent for the conduct of such elections were not met by RISEC. In reversing the Federal High Court judgment, the Court of Appeal held that the lower court lacked jurisdiction to hear the case and the issuing orders. All right, so it's a busy day at the apex courts in the nation's capital, Abuja, and that is why I had to bring in a senior advocate to make sense of what is going on as far as the cases are concerned. But focus is the Rivers State issue, and the 5-member panel led by Justice Uwani dismissing the appeal filed by the Rivers State governor against the leadership of the Amewule-led House of Assembly because the governor, we understand, had to withdraw the suit through his counsel, Mr. Yusuf Ali. Mr. Senior Advocate of Nigeria, Mr. Wahab joins us right here in our Lagos studio. Thank you so much, sir, for coming on the program.
Thank you for inviting me.
And I must thank you for coming at a very short notice because this is as short could be. But I know you've seen maybe some highlights of what is going on. We understand, I'm looking at the list here, so I'm literally walking my phones as we're talking. We have like more than 10 cases. Some is basically sister appeals and cross appeals at the Supreme Court that involves the River State government, House of Assembly, and other issues as well. But what do you make of this latest decision by the Supreme Court dismissing the appeal by the governor of River State against the Ameole-led House of Assembly? We understand the governor actually had withdrawn the suit.
Well, the judgment of the Supreme Court and the development leading to the dismissal of the suit, for me, is significant in two main respects. One, it shows the supremacy of the Constitution. We know the Constitution is the ground norm, the uncommanded commander, and this, the principles underlying some of these decisions are already spelled out in the Constitution. So what the Supreme Court has done today is to reaffirm constitutional provision. That's one significant, fallout of the decision. Secondly, I'm impressed by the two lawyers on the other, on both sides are very, very eminent. They understand the rules, they understand the Constitution. So the fact that Yusuf Ali SAN has properly advised his client to withdraw the suit, because ultimately, without that withdrawal, we all know and speculate on the outcome. So I think it's dignifying of Mr. Yusuf Ali, Malam Yusuf Ali, to have withdrawn the suit. And that has also made it very easy for the court not to write a lengthy ruling, just to also dismiss. And then the last implication is the fact that the suit as it is stands dismissed, which means that issue cannot be litigated again. It will have been otherwise if it was merely struck out, which means the issues can still be raised again. So what the Supreme Court has done is to lay the matter finally to rest, which means the 27 members of House of Assembly are now officially recognized.
That's the implication.
The implication. It also means that whatever decisions are taken previously at the behest of the three-member, House of members of the House of Assemblies are now declared a nullity. That's the implication. The implication is that the only 27 members of the House of Assembly is fully recognized right now.
All right.
It's not a victory for any party. It's a victory for constitutional supremacy.
I'm happy the way you landed. So, but let me bring a few things into context. So,
yes.
What this means for the Rivers State government and the Rivers people.
Yes.
From what because I've learned by listening to learned minds like yours to stay within what the language of the law says,
yes,
and allow you to do the interpretation of what the law says.
Yes.
And you answered the question because I wanted to ask you, what does this mean? Does it mean Ameole is now recognized as a leader and all of that? So you've answered that. So the 2024 budget, 800 billion. The 2025 budget, 1.2 billion, I think also 1.1 billion, 1.1 trillion were laid before a 3 to 4 member house. What happens now? That's one question.
Yes, okay.
Second question is, there were all kinds of vetoing of the governor in terms of legislation. They pass a bill, they send it to him, perhaps he didn't assent to it, or they vetoed the governor. I think if I look at my list, I may see up to 6 or 7 or almost 10 of them. What happens to all of that happened within the crisis?
Well, the first implication is that those budgets are a nullity. The 2024, insofar as they were laid before members who are not duly constituted. And the implication of the dismissal of the suit now is that, you can only lay, those budgets have to be represented to a house duly conveyed, which is a 27-member recognized House of Assembly members. So the 2024 budget and the 2025 budget, which you have made reference to, are no longer recognized.
But the 2024 budget has been expended.
Well,
the year has ended.
Well, the implication...
What does it mean not to be? Is it that in the eye of the law there was no 2024 budget? What does this mean in law?
Exactly, that is the implication. That's the implication. You can't put something on nothing and expect it to stand. If you put something, you have to something or nothing, then it amounts to a nullity. And again, there should, and I think the controversy, in my view, without trying to take sides with any of the parties, is needless. There are clear-cut provisions about what constitutes a quorum of a House of Assembly. If you look at Section 96, 97, 98, 99, and all that of the Constitution. Asking a three-member House of Assembly members to sanction any decision is a travesty. What is going on in Rivers State, in my view, is the enthronement of the law of the jungle. And this is a democracy by the rule of law. I think all sides must reconcile their differences and allow this democracy to work. My view is that now that the Supreme Court has even made this pronouncement, the two sides must now close ranks and allow the Rivers State people to enjoy democracy dividends. Because what we are practicing is democracy by the rule of law, not democracy by the rule of the jungle.
So what does this mean? Because I'm trying to look through all of the appeals and cross-appeals. We're still expecting some more judgment, even with the House of Assembly. The language used here, challenging the leadership of the House of Assembly led by Martin Ameowule. What happens to the issue of defection?
Well, as far as this judgment is concerned, there is no defection.
So the judgment so far, because
Yes.
we still have more judgments
So
coming.
far,
Yes.
there's no defection. And if there is no defection, then any decision taken without regard to that reality is a nullity.
So what happens to the issue of defection in houses of assembly? Because now this is like a learning curve, because it's also a court of policy, not just of law, as far as the Supreme Court is concerned. So what happened? Because there's been, for instance, now there's an issue with Ned Nwoko of the House of, Senate, where he defected, and they are quoting Section 68(1)(g) of the Constitution, that there's no division. So what happens to those kinds of situations like this, given this judgment of the Supreme Court?
Court constitutional provisions as to circumstances under which a member of a political party or a representative or an elected member of a political party can validly defect. A division must have arisen, in fact, or from the circumstances, a division in the party from where you are defecting. And it's a matter of fact whether there's a division or not. So if anyone has defected and the party from where he or she is defecting feels aggrieved about the defection, particularly if they are fast suggesting that there's no division in that political party, then it is open to challenge. It is when such a challenge is made and a fact like that is brought before the court, that the court will have the opportunity of laying down the ground rules. Because this suit was withdrawn, the Supreme Court did not have the opportunity of examining the merits of the case in terms of whether the defection of the 27 members amounted to a defection.
So do you think
the suit was simply dismissed?
Okay.
Which means the issue did not arise.
Sorry.
That's the implication.
Let's see, do you think that this was political resolution just to save the court some time to solve, not to get into all of this?
Well, like I said, I must commend the two leading, counsel yes, on both sides. Some of our very best. Chief Wole Oladipekun and Yusuf Ali here are some of the best lawyers anybody can get as far as this country is concerned. They rank among some of the very best, most eminent. So there are people who will properly advise their client about the merits or otherwise of the cases being litigated upon. I want to assume that a lot of horse trading has taken place. A lot of reflections have taken place, and maybe there are attempts to reconcile the feuding parties to allow governance to take place in Rivers. But that's critical. At the courts, the legislature and the executive all exist to deliver on effective governance. And so when we say reason is prevailing,
Okay.
or reason has prevailed, because it is not in the interest of the River State people for this kind of uprising.
So let us take my apology. You know, when we sit with you, it's also a learning curve for those of us who are not lawyers. So, because if this was litigated, if it wasn't dismissed, for instance,
yes,
and we saw the merit of the case and all parties were heard, the judgment was given, we see the reasoning of the judges, it becomes a precedent. Because some of the precedents we have right now, just I think Ifeda Begunde in Akure, the Federal House of Representatives, when he left Labour for ACN, and the court judgment, the Supreme Court said, look, you're out, because the party did not divide to the point where it couldn't function absolutely. So I'm wondering what we can take away from this particular case, given that it's a dismissal.
Well, the takeaway is that this issue cannot be litigated again. The Supreme Court, like you say, is a policy court. The highest court in the land, it has pronounced dismissing the suit. And you must know the effect of a dismissal. It means that the issue has been resolved finally. So you cannot come and say, okay, you want to relitigate the issue again. Like I said, it would have been different if it was merely struck out, in which case parties can then resume hostilities again and then relitigate the issue. But unfortunately, like you have rightly mentioned, we are unable to see the justification for the decision taken by the Supreme Court. You know, at any stage before judgment is delivered, parties are at liberty to file a notice of discontinuance or withdraw whatever claims they have before the court. And in exercise of that right, the governor's side, Governor Fubara, has decided to withdraw the suit through his counsel. And I say that is salutary because we have also saved valuable judicial time that will be expended in entertaining arguments and then in writing judgments.
It's an interesting future as far as this case is concerned, because you know, you and I have been on this from literally from the very beginning.
Yeah, we started
we started this since October 2023.
Exactly.
When the fireworks began, we were sitting on this same chair. This is almost how many a year and plus after.
I think the message I want to get across to political leaders, the political elite, is that we operate a democracy governed by the rule of law. And the supreme document regulating this democracy is the Constitution. The supremacy of the Constitution has been guaranteed by Section 1.1, Section 1.3 of the Constitution. And so all actors in the political process must endeavor to follow the Constitution in their actions. Whether you are dealing with a case that favors you or a case that is against you. I think that's the lesson we should take away from this. We can do political resolutions. We can, but when it comes to matters of law, we should follow our constitutional framework and all the relevant statutory and other enactments regulating the process, because that will save a lot of time. It will stabilize the polity. It will ensure that there's no, we do not, saddle the court. The Supreme Court is already overwhelmed with a number of cases waiting for adjudication. So when you begin to litigate issues that are clear, even by the express provisions of the Constitution, what you do is not only to overheat the polity, you also saddle our courts with needless litigations and time that could have been expended in adjudicating some other matters of pressing national importance. I think the takeaway here is that politicians must behave always as Democrats. There's no way you can practice democracy if you are not ready to be a Democrat. In fact, it's a distinction without a difference.
That awareness, we need to create it with our political class. Because there's a lot of Democrats that are needed in democracy. And it's a challenge, given the fact that we're coming from a military background. Boss, thank you so much, Senior Advocate. I know that I wanted you to comment on one, but since the Supreme Court is going to make a statement on it in judgment, I want to leave it at that. That has to do with the appeal court telling the Federal High Court you have no jurisdiction over issues of local
But if the
government
Supreme
election.
Court has not pronounced on it, and the matter is still pending before the Supreme Court, it will be suicidal for anyone, including myself, to comment.
Yes.
For that matter, will be sub judice.
Absolutely, which is why I want to save you from that trouble.
Thank you.
It's an omnibus of appeals. So as we get them and we combo all of them, we'll get to get you back to give all your interpretation. Wahab Shitu is a senior advocate of Nigeria. Thank you, sir, for coming on the program.
My pleasure always. Thank you.
All right, let's still stay with the judicial matters. Parties to the Edo State Governorship Election Petition Tribunal have started arriving for the day's proceeding at the National Judicial Institute in Abuja. The candidate of the ruling APC, Governor Monday Kwabula, is expected to open his case today as the People's Democratic Party candidate and the Independent National Electoral Commission have both closed their cases last week. The Edo State Governorship Election Tribunal adjourned proceeding on Thursday last week after INEC told the three-man panel led by Justice Wilfred Okpochi that the Electoral Commission will no longer call any witness to testify in the matter. The PDP governorship candidate, Aswe Godalo, is challenging the electoral victory of Governor Kwabula, who was declared winner in the September 2024 governorship election, polling 291 votes to defeat his closest rival, Aswe Godalo, who polled 247 votes in excess. The tribunal, which started its sitting in Benin, the Edo State capital, was however moved to Abuja owing to rising security challenge. And we can tell you that the governor has actually closed his argument as far as this case is concerned. And that's it on the program. Thank you so much for your time and company. Our eyes, our ears, and our phones and devices are on the nation's capital to get all the scoop as far as the Supreme Court judgment is concerned. We'll bring you up to speed in our subsequent bulletin. Thank you. I'm Jeffrey Ozongo. You've been served on Lunchtime Politics. Bye-bye.